Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, Sarah Boone, just when we thought she was getting along pretty well with this new attorney, she has written a long letter to the new judge. So I'm going to go through that for those that are interested, because it's always fun to take a look at Sarah Boone's letters to the court. Alright, so this one was written actually on January 19th. And as you can see, it was written to Judge Michael Kraynick. He is the new judge on her case. It states Sarah Boone. She has her case number. Now this is handwritten, so bear with me. It may be some parts that are hard to read. Honorable Judge Kraynick. Finally, a new judge. It's strange how the Lord works, as I was in the process of trying to disqualify Boone after being my judge 4 years and me still incarcerated with nothing to show, other than 7 different attorneys, not by choice. Well, I might differ you on that one, Sarah. Whoops. News clips of me walking in and out of the courtroom and everything relative to my case permitted to be slathered on the global internet, in which I have not seen myself. I thought she's seen a lot of that stuff. I guess she's not watching TV anymore? Do you not have access to the internet anymore, Sarah? Because I thought, remember you used to say your suitcase videos got all these views, and I remember all that. So I'm just curious, are you not able to see those yourself anymore? I felt he was the ticket holder to my overly hyped, illicitly distributed, misconstrued criminal case. I don't know why she thinks that's in quotes. It is a criminal case, Sarah. And great reason I am still here. Again, ongoing 4 years and 7 attorneys later, not by choice. See my letter dated 6/29/23 on clerk's website. Well, Sarah, you did waive a speedy trial, so that's sort of a problem in and of itself, right there, that you did waive speedy trial. While still waiting to properly elucidate the court, elucidate, it's funny how she can use some of these words, but then she puts me up there, so go figure. Public in the world, and after whatever the dysfunction was in the attendance part of my most recent PTC status hearing, which I am trying to ensure my automatic attendance futuristically. Please see my draft motion included. I am still trying to have my attorney submit on my behalf. Yeah, apparently she hand wrote a motion, which you can't write your own motions apparently, but Sarah's special, I wanted to bring to your judicial attention the following information so you and the world are aware it is not who I am ever delaying trial, as Wooten inappropriately assured me of doing in a past hearing, especially now that you have mandated a trial date to be had in May with no further continuances, leaving less than 4 months to put together and complete what should and could have been done already. What happened in all the 4 years prior? Please see all of my correspondence online. Well, Sarah, I think we're going to have to go back to A, you waived your speedy trial, and B, this is attorney number 7, so I don't think Wooten's your problem. I mean, I realize you're trying to push off your problems on someone other than yourself, but you got to take some blame here. You know what I'm saying? You got to take blame. I mean, it's not all about everyone else. And, Sarah needs to take her own blame. To date, Winston E. Hobson has been my court-appointed attorney for 133 days and counting. To date, Mr. Hobson has only met with me 1 time for a total of 3 hours, 11/7/23. Uh-oh. So I guess she's not liking him either. I think we got another problem. To date, no phone calls have been received by Mr. Hobson, as his phone does not work properly. For further immediate, much-needed communication to be made between client and attorney. You kind of have to wonder, remember she couldn't reach Bankowitz by phone. You think maybe it's an issue on Sarah Boone's end and not so much the attorney's end? To date, I have mailed 5 letters to Mr. Hobson trying to communicate my urgent need to speak to him. To date, I sent 1 letter to the investigator in my case to contact Hobson to contact me and see if he can assist in correcting the phone problem. Also to inquire when anyone is coming. To date, I feel I am not being included or heard or cared about in my case. Again. From the continued miscommunication, again, with Mr. Hobson, and time-consuming, undiscussed entries are being made on my behalf. The continuance I did not know about, the waiver of appearance I did not know about, along with other documents, and I am never sent copies of anything I filed, so I know. I keep trying to tell him about with no response, furthering the already massive dysfunction in my 4-year case. I was hoping in the PTC status hearing on Tuesday, 1/6/24, I could at least play, quote, catch up in the courtroom, unquote, for 5 minutes, so many of my attorneys have done prior, including Mr. Hobson, in the 1 court date I've had for a continuance of a continuance, 10/30/23, to express and emphasize the need for him to communicate and schedule a second very overdue meeting. I still have not even heard from Mr. Hobson about our missed PTC status hearing. What's the status? To date, 1 out of 133 days and counting, attorney and his client have met. To date, 3 out of now 3,192 hours, attorney and client have discussed partial general case information. To date, I still have not seen my discovery. Oh, dear, dear, dear. Your Honor, when is the next status hearing, please? Especially since we were not at the last PTC status hearing, and especially since I'm trying to communicate with my attorney in more than one way to fully maximize and utilize the minute amount of time allotted before trial, my fair, appropriate, lawful trial. I am still wondering why, though, I've had to wait for 4 years for something to finally happen in my case. Asked Judge Wooten, I wonder also, was I the oldest case on his docket? I don't think you are, Sarah. I think, first of all, I am one to really hate the excuse of the pandemic, but that is still part of the problem because the whole suitcase situation happened right before the pandemic, number 1. And number 2, your constant issue with attorneys and you're waiving speedy trial. And then no. From what I understand, you're not the oldest case, I doubt, in Orange County, and let alone all over the country. But I'm pretty sure you're not the oldest case in Orange County. I'm sure I could look into that. I am actually curious now, so maybe I'll look into that if anybody knows, let me know in the comments. Either way, I'm still here, waiting patiently and very excited to get this highly anticipated, quote, show, unquote, on the road. Well, I know we're looking forward to hearing, all you've got to say on the stand, because all we've had to look at is the body cam and your interview, and we all know how much you really do want to get on that witness stand, Sarah. We really know you want to, and I'm actually eagerly awaiting it as well. I await your overdue and very needed judicial direction, supervision, and intervention. Thank you in advance, Judge Kraynick. Welcome. So she welcomed him to the case. That's nice of her, isn't it? Here's the thing, Sarah. I don't think continually writing to these judges is going to help you. The fact that Winston Hobson, your new attorney, you're claiming has not communicated with you, and then you remember how you had issues with previous attorneys with the same problem. Again, I have to wonder if it's you and not so much them. Remember, you're not the only case they are working. And from what we understood during your earlier this month, during that pre-trial hearing, it looked like he was doing a lot of stuff for you. And I was under the impression, obviously wrongly, that you guys were working well together and things were going well. He wants to get the show on the road, it sounded like, and he's trying to get you this expert approved. So apparently what it looked like to everybody else was just not true, at least not according to this letter anyway. So this is the motion that she decided to write up. It's odd because I don't, I mean, I'm not an attorney and I don't play one anywhere. But we've read a lot of motions here on the channel, and I've listened to a lot of motions on other creators' channels, and it's really odd to see handwritten, and clients don't write motions, attorneys write motions. So, but Sarah decided to write her own because, she's Sarah Boone. In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, state of Florida, plaintiff, and she puts the case versus Sarah Boone, defendant, motion to be included in and allowed admittance to all defendants' pretrial conferences and hearings. Comes now, defendant Sarah Boone, by and through her undersigned attorney, Winston Hobson, respectfully requests permittance to attend all my pretrial conferences and hearings ongoing until the conclusion of my criminal case. I don't think you can speak for your attorney. I think he speaks for you, but okay. Per FRCP Rule 3.22001, the following is stated to lawfully allow my inclusion, participation, and requested admittance. I guess she's been hanging out in the law library at the jail. The trial court may hold one or more pretrial conferences to consider such matters as will promote a fair and expeditious trial. The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. In support, the defendant alleges as follows. 1. These pretrial conferences are for my personal, individual criminal case. If professional YouTubers, news channels, court TV, etc. are given permission and allowed to entry to the courtroom for viewing, and the judge is also allowing the conferences to be streamed live with all the court minutes uploaded to the internet and world, I, the defendant, should be included foremost. I don't think anybody disagrees that you shouldn't be there, Sarah. But remember, you've also complained about the amount of time it takes for you to be at court for 5 minutes. So, which is it? Do you want to be in court for these pretrial conferences and what have you, and spend your entire day out of the jail and in holding cells and sitting in waiting rooms and what have you and in vans, or do you want to stay in your luxurious cell block? I don't know. Can't be both. 2, I may not have regular, consistent updates or communication with my court-appointed attorney, and by attending all my PTCs and hearings, I will know current status, important dates, casework being completed, changes in parties, timeframes, expectations, all pertinent information. I, the defendant, have a right to know, want, and need to regarding my case. All information is important, relative, and necessary to me. 3, I am not consistently included in the certificates of service and sent copies of any documents being filed in court regarding my case. It's requested numerous times by the defendant in writing and verbally in the courtroom, neither by the judge, the court, or any attorney or attorneys. By attending my pretrial conferences, I will know what documents have been filed, need to be, and will be for and in my case. Another way I can know is what's going on in my case and being worked on. So I'm guessing she has like a notebook or a binder in her cell with all these paperwork, because I don't know. Number 4, in complete overall support, it is my right by law as an individual, defendant, and inmate to be included in any all developments made in my case. It is also my right to finally achieve success in any and every aspect possible in my case. By attending and being included in my pretrial conferences and hearings, said success can and will be accomplished fairly, faster, and properly. Wherefore, the defendant, Sarah Boone, respectfully asks for the Honorable Court to grant my motion to be included going forward to all defendants' pretrial conferences and hearings. And she put her name and looks like her address there at the jail. And she certifies that this original document has been filed by U.S. mail with the clerk of court. So I guess she copied all that stuff from previous stuff. Oh, she mailed it. Look at that. There you go. Well, I don't know what to say. Again, I was under the impression earlier this month that things seem pretty good, Sarah. I thought you and Winston Hobson were doing well in your client-attorney partnership or what have you there, and that things were moving forward. It sounded good at the pretrial hearing, but I guess that's not completely the case. So I don't know what to tell you. You're, I have to say, and I know you're not going to go for it, but I have to say at this point, you might be better off taking a plea deal if the state offers it. I know. But, or just go with it. Like I said, Mr. Hobson seems to be trying to get you your expert, trying to get it approved so that you can have this this defense that he put out in his paperwork with the previous filings, and then you can have your court appearance, in a few months. So I think it could be done in the next 4 months, Sarah. I really, really do. I don't know what else you think is going to be a good defense besides the ones that have been potentially brought up for you, But I'm kind of at a loss at this point. You don't really offer anything except that you want to be there, and then you want to complain about everything when you are there. So, I don't know. I'm not sure the Orange County Court in the 9th Judicial District Court there can ever please Sarah Boone. But that's where we are right now. Guess we'll see what happens. See if we get another hearing before we get the next status hearing. See if anything happens there, any more filings. I'll keep an eye on that, guys. But let me know what you think of Sarah's latest letter and her handwritten motion. Kind of curious what the new judge thinks of all that. All right, guys, I hope you have a great rest of the day. And most of all, stay safe.